as an IP experience for close to 5 to 6 years, wherein I was supporting the insolvency professionals for around resolution professional, successfully resolved. So this is my small brief background, and I thank ICSI IIP for giving me this opportunity with a very good thoughtful topic. Anjali ma'am, am I audible?
Yes, ma'am, you are audible.
Okay, thank you. So we'll just start the presentation on navigating the professional ethics, a guide to insolvency professionals. So this is a small interesting picture I want to show depicting the role of an insolvency professional. When initially for insolvency practice law, first few years were like very, very challenging when the how when the new laws are introduced, how the transition takes place and how the implementation of the law becomes challenging. And with the kind of experience, all of the insolvency professionals who are experienced with the available by IBBI and industry, how the challenges are faced and how to what extent banks are being the responsibility. And the four pillars of IBC are the IPBI regulator, insolvency professional, and the IU. The insolvency professional is the one of the most insolvency code. The law is 8 years old, and I'm into IBC close to 5 to 6 years. I'm into this practice national level and also international level. I have attended few conferences at kind of challenging role which the insolvency professional across the globe is having is like the most challenging, I can say. As a chartered accountant, company secretary, cost accountant, and advocates, we have a different set of challenges. But as an insolvency professional, so here I am just bringing the context. Insolvency professional is like David, who is a very small stakeholder, but however, with his confidence and with his skill set and with his experience in the domain, as well as the kind of qualities which are required for a successful handling the processes under IBC, they can beat the whatever are the challenges, like how David faced all these through various kind of traits and be successful, and also be and set an example, managing the up to the insolvency professional. I can say I have seen close to 30-40 CRP assignments. Each assignment has its own dynamics. Each sector has its own dynamics. Each sector has its own specific, along with the process, whatever the prescribed guidelines we have to follow. We have to have a separate skill set wherein we should be able to identify the issues with the CD. So the CDs which are admitted into CIRP or whatever the process we are handling as an insolvency professional, we should be able to identify the relevant issues in that specific process, along with the routine issues which we will come across while complying with the laws and regulations. So I'll just start my presentation. So the topic is navigating professional ethics. So when we see in general parlance, ethics and professional ethics. So we see in simple parlance, everyone knows what is ethics. In even in Indian mythology, and if we see all our Puranas and whatever the religious script, like the message will be to have a ethical, moral standards. That means morally you should be able to recognize what is good and what is bad, and what is right and wrong. So I can say this is every day during the, when you are handling a process under IBC, you should be able to identify what is right and what is wrong. And that based on your judgment, you should be able to gauge this. And the term is also applied in systems and theory, wherein the moral values or principles are the base. And again, when we come to professional ethics is also again recognizing whether morally we are right and wrong, but this is done through adoption of certain standards. Sorry, it got disconnected. So you are able to view my screen.
Yes, ma'am.
Adoption of standards for application of our skills, knowledge. So these standards are there in black and white. Where for insolvency professionals, I can say the code is the main base for all of us, and along with that, the various regulations, rules prescribed therein, and along with all the applicable laws. So when we come to the definition of insolvency professional in the name itself, there is a professional. So we are a professional who has certain expertise in the field of an activity. Like we are either chartered accountants, company secretaries, or cost accountants, or advocates, or management professionals with some experience. So here the code was right that they wanted an insolvency professional to navigate the entire processes successfully, because already the CD is into stress and lot of issues would have been already there in the companies. So a seasoned professionals having some expertise in some field or activity the code has prescribed some 10 years of experience for the professionals to get themselves registered as an insolvency professional after taking up the limited insolvency exam, and also undergo some 58 hours of training. I personally have experienced these 58 hours of training is mandatory, as IBBA has also made it mandatory. It is compulsory as a professional, although I was having 10 to 12 years of experience. But the way you think about the profession completely changes once you attend these training programs. So whatever IBBA has prescribed to register as an insolvency professional, that process is perfect to the insolvency professionals are replaced under old regime. The official liquidators, official assignees, administrators, official receivers, and some operating agencies or nodal agencies were there. And the insolvency professional is replaced by repeal of various acts. The IBC has replaced the insolvency professional. So much of scope of work is assigned to insolvency professional. So there will be a lot of roles and responsibilities which IP has to take up and do it diligently. So basically the definition of insolvency professional is to become an insolvency professional. You are an eligible person who is enrolled with an IPA as its member first, then registered with IBBI. So to get your registration registered as a member of IPA, to be a member of IPA, you have to qualify for exam and have requisite experience and undergo the practical training of some mandatory hours. Then they will verify all your records, and the kind of diligence exercised by IPA is very strict. They will review all the documents. I had experience at Singapore. Even the IPA used to call me and take the confirmations from my Singapore company also, to ensure that I really had 10 years of experience. So to register with IPA, you need to provide all your documents, especially regarding your education and experience. And also they will go through your credibility through your CIBIL reports. So by all these kind of documents which is required to be registered as an insolvency professional, so hopefully we will understand what is the kind of responsibility the code has put, and how our regulators are ensuring that they are not registering the wrong person as an insolvency professional. And the guidelines are prescribed by So based on regulations, the member is registered as IPA after qualifying and other compliances. Once we are registered with IPA, then the registration is processed with IBBI. Then IBBI will register. So the insolvency professional will have two numbers. One is registration with IPA number and the IBBI number. So in the IBBI number itself, our IPA number will get reflected. So under IBC, there are a lot of provisions where the duties of the insolvency professional are clearly laid down, especially during the insolvency, corporate insolvency resolution process, section 17 to 25. The duties cast on the resolution professional, and from there on, from 25 to 40A, how the process should be carried out. The taking over of the CD issue, the issue of public announcement, and the issue of preparation of information memorandum and preparation of RFRP, calling for resolution plans. From the time NCLT appoints you till the resolution process, how the resolution professional should the CRP process, the entire regulations are very, very clear. The insolvency professional has to be very thorough, and model timelines are prescribed. These are the basic set for the CIRP process. So when we come to the model bylaws governing IBBI regulations, what exactly is IP is required to registered with the board? What the board imposes certain duties on members while performing their duties as an IP. So when liquidation, any bankruptcy process, any processes which we are carrying on, and if there is any deviation in the conduct of the insolvency professional, the IBBI in its disciplinary action, they are recording words. So if we see, as per regulation 6, the member that is IP, while performing his duties, should act in good faith in the discharge of his duties as an IP. In good faith means, so when the either section 7, 9 or 10 application gets admitted, and when honorable NCL on the recommendation of either financial creditors or operational creditors, or on the recommendation of on the recommendation of financial creditors, or by the CD or NCLT by professional, you are supposed to take over the corporate debtor in good faith, and while corporate debtor, you have to act in good faith. The stakeholder try to deviate, try to provide some information to you which you believe to be correct, but however you have to exercise all the diligence and try to rely more on the documents than from the deviate. We should focus mainly on the process in good faith without getting diverted from any kind of issue. Then endeavor to maximize the value assets of the debtor. So during the course of CIRP process or liquidation process or voluntary liquidation process, the insolvency professional always should put in his all best out efforts to preserve the value of the asset. In case if there is any kind of lenience in not able to manage the value of the assets of, or if there is any deterioration in the value of the assets, the insolvency professional, that is the resolution professional or liquidator, should immediately take it up with the committee of creditors or stakeholder consultation committee and seek their opinion or seek their guidance on this regard. And the resolution professional and liquidator is supposed to act in good faith and with all the experience he has to be guided by the whatever the advice the COC members or stakeholder consultation provides, he has to consider and act within the guidelines. Like in case if there is some value of asset is going to deteriorate, and the value of the asset is as per the regulations, in case if the significant value of assets, some percentage is there, if that much value of the assets is to be sold, the RP has to take approval of the COC with 66% and also make necessary application to NCLT and try to protect the value of the assets of the corporate debtor. So here, in case if unable to exercise diligence, that is a common man's and common man exercises, it is even beyond that, the professional expertise, we should put all our best out efforts, and we should have all the records to showcase that you have put in all your efforts. Whatever IPs have to do in, I'll just give one example. In one of our case, the leather goods manufacturing company, they were supposed to send some export bulk to foreign countries, but there was some due to some issues, the material was lying at the customs itself. So our IP has taken approval from NCLT. He sought approval from COC and took and made application to NCLT and took approval to sell that asset, so that the value of the asset is not eroded. So IP has to discharge his functions with utmost integrity and objectivity. So the IBBA is making note of lackadaisical approach of insolvency professionals. That means they are putting a casual approach when they are discharging their duties. It is not that. Some CD with the CD is already in stress, but when you are trying to resolve your efforts, you should object and should be independent and impartial. So when admitted, where I am a RP, I have around 1,000 employees. So people come and try to showcase that one department is important, and one of the director comes and says he is very important, critical in growth of the company, and the other director is responsible for the stress in the company. So they try to impose their experience in the CD on us. So we should be able to have our own independent judgment, and we should be always impartial in the process. And we should discharge the functions with highest standard of professional competence and ethics. So this highest standard of professional competence, highest standard of professional competence. So when some efforts are required to bring in the resolution or bring a better price or maximize or usually in process medium companies, the IPs will put around 2 to 3 professionals to monitor the CD or carry on the process and managing the process. In case if CD is small with very minimum operations or with very few staff, the insolvency professionals will engage very few members from their side. So we have to ensure, we have to see that we put the right people and right team in case required. Even if one more team member is required, which will ensure that the standard of managing the process makes a difference, we have to take it up. And the sixth one, which is very important, is upgrade is professional expertise. So this is very, very important. We usually say in one of the NCLT member was saying, the corporate social responsibility, the similar kind of responsibility is PSR, that is professional social responsibility. As a professionals, we also have some kind of social responsibility. Which is useful not only for ourselves, but also we are able to give our best efforts in successful restructuring of the stressed assets. So always we should upgrade the professional expertise and perform our duties as quickly and audit or cost audit. All the timelines are prescribed, but however, the model timelines prescribed for each and every action is strict regarding the efficient and quick compliance of the timelines. Like RP, I can say in the CRP process, RP should be always every day. There is some, if CD is a going concern, every day there is some kind of important issue which will happen. I have handled very big CIRP in 1 or 2 days. You feel like you have complied something, then immediately something is already there on your table for compliance. And when it is a big company and going concern, IRP and continued as RP, the company had five verticals of operations. So five verticals, one vertical was regulator was UIDI, other services. One vertical SEBI was the one of the um, uh, were the interface. And usually most of the times in these verticals, always one or the other issue comes up, and we have around 14 centers in India. 14 centers CD had operations, so one or the other center has some issues, so you will be dealing with these each branch heads. And at the same time you have to ensure that you verify the claims were almost close to 7,000 claims have come. So you will issue public announcement and you have to ensure you verify all the claims and that compliance 30 days. You have to appoint valuers within 7 days of your appointment as RP. Then you immediately you have to have your of India. So the kind of diligence team they put you behind you, RP, you have new regulations, the notified new guidelines. The for each process, the RP has to have a separate mail ID. So a lot of mails keep coming, and you as an RP and as per the applicable guidelines, you have to reply to the stakeholders within some specified timelines. So you ensure that you are checking all the mails, and as an RP, although you have your support team, but I personally recommend to each one of you that all the mails you should read and you should be aware of things. Even someone is managing your work on your behalf, but you should be able to understand everything because the content of the mails, because ultimately the stakeholders like committee of creditors, NCLT or IBBI, everyone will contact you only. So even your support team is handling some, you should be completely aware of things. Then comply with the applicable laws in performance of duties. This is very, very tricky, and all the applicable laws means all the applicable laws, like even Companies Act. So here, just one example, the board of directors powers are vested with the interim resolution professional or resolution professional. That doesn't mean the duties of the board of directors are suspended. So as a insolvency professional, you are now the designated CEO and you are the managing director of the company. So it is your responsibility to call for the board meetings. As a compliance, we have to call the board meetings. Then regular audit, whatever applicable laws like GST. When the company admits into CRP, you have to take CD is going going concern. You have to take fresh GST registration and start paying GST in that new number. Have to ensure that the contribution of PF is also deposited. ESI payments go in time. TDS payments go in time. And one more important duty is you have to maintain confidentiality of information obtained in the course of professional activity and only disclose if such information is required under some law. So the whatever information we receive during the conduct of the process, that has to be maintained confidentially until and unless it is required under some law. Just as a practical, for the interest of members, I just want to share one thing which Bank of America has identified certain traits to be a successful bankruptcy lawyer. So these are the full few following traits. They said knowledge and application of NCLT procedures, effective dealing with debtors and creditors, proficiency in insolvency laws, and bring experience whatever you have over years to the process. Here, the NCLT is the adjudicating authority under IBC. So we should be aware of how the applications are made to NCLT and how the processes are within. And one important point I want to discuss here is whenever NCLT hearings are happening in the process where you are appointed as RP or liquidator, ensure you are always attending the hearings. Especially in Hyderabad, the bench one member judicial member used to always look up to insolvency professionals for understanding exactly the of the NCLT processes. Then effective dealing with debtors and creditors. This is very, very, very critical for the success of the process. Because see, when CD is a going concern, we should, and we are just appointed as insolvency professional, we should court appointed officers, we should bring confidence to debtor and creditor. That means by the first COC meeting itself, the what we present at the first COC meeting is very, very critical. So that there is a confidence which is built with the creditors, the credibility. So in my case, the Carvi data management, I was appointed as IRP, and sitting with my team for verification of close to 3,000 claims and understanding the operations of the debtor. So even though we are experienced professionals for the company, that means the financials, the legal cases, what are the receivables of the company, and who are the major vendors, who are the creditors. And as initially I said, we have to each also try to speak to some creditors who will be part of COC and understand from them what exactly are the issues of the company and what is that they are looking forward to us. So the kind of agenda which was presented at the first COC gave little confidence to the creditors. And I started interacting regularly with the debtors and also the employees, and regularly updating them. Each like we had 14 centers, each 14 centers branch had one WhatsApp group was created, and for committee of creditors one WhatsApp group was created, and for the legal professionals who were pursuing, we had a group. So always quick updates were taken, and I used to regularly update the creditors, and majority of our creditors were in Delhi and Mumbai. So every 2 months, 45 days, I used to visit them and explain them exactly what are the practical issues and what was happening. Regular updates were sent along with the COC meetings, apart from COC meetings, and should be able to interpret. One is proficiency in laws, and we have to bring our experience to the assignment. So each assignment, as I said, each assignment is different. Along with the issues regarding the CD, we also need to comply with all the laws, applicable laws. And whatever that 10 to 15 years, whatever experience, 10, 15, 20, 30 experience, whatever we have, some of the trace may in the assignments. So while managing the assignments, we should be uh, very proficient in the laws. So one is assessing the right fee for the right case, application of local laws, clarity in presentation of cases, understanding of the business dynamics, and identification of professionals for supporting the process. This is very, very, very critical. See, understanding the business dynamics and identifying the professionals for supporting the process. When we do not when we do not understand what are the business dynamics of the CD, and when we don't put the proper team, support team, or any legal professionals, or who is going to support us in the success of the process, then we will be missing on lot of compliances. Lot of issues will come up before IBBI or NCLT. Again, I would like to share my experience. In my case, there was an enforcement directorate attachment. There was an ED attachment against the main holding company, and we were the subsidiary, the subsidiary assets also. In IM, this was disclosed to the resolution applicants, prospective resolution applicants. Pursued the litigation. We also filed the cases before the High Court for to dispose this writ. What we filed a writ before the High Court to dispose, to allow the CD to go for resolution, since the CD was into very critical citizenship services of the country. And even ED understood. I went personally and met ED officials and explained them that what is the significance of CD, and even if ED attachment continues, there were no assets in the company. Completely, there were no assets. It was only security and financial assets. That is, only some receivables were supposed to receive, and company was holding very good licenses. government projects. So just based on these few like licenses or receivables, we were able to get good resolution. And there are a lot of legal issues in this process, in the process of CD, but I have ensured that I have put some dedicated professionals on this team. And let me tell you, though, those professionals are not experienced or any seasoned professionals. I have put majority of my team was fresh GIP professionals, fresh 3-4 years pass out advocates who have worked with me almost till late nights, and we were able to pursue litigation meritoriously. We were getting good orders at High Court as well as at NCLT, and we were able to get the resolution of the company without handling lot of legal issues. So code of conduct, see, along with whatever applicable code, regulations, rules notified, applicable laws, there is a code of conduct for every professional. So even for insolvency professionals, the code of conduct is there in the first schedule to the regulations of IP regulations. So the IP has to abide by the code of conduct and bring, and while practicing the profession, he has to abide by the focal areas, which is integrity and objectivity, should be independent, impartial, and should have the professional competence. And always one point is representation of correct facts and correcting misrepresentation. Suspended powers, they are trying to give you some misrepresentation, they are misrepresenting, they are not giving you correct facts. You should be able to have your on the facts or documents and come to conclusion. Then one important the trait is the focal area is observance of timelines. So whenever we are missing on timelines also, many of the IPs got notices that the timelines are not followed. And ability in respect of information management. See, information management is also very, very critical, because the CD is into stress. Majority of the information is not made available. Financials will not be audited. Even the creditors will not have the latest information or data with them. Whatever data we will be able to collate, which is useful, which we will be putting in the information memorandum as well as in the VDR data rooms, which we put for the benefit of prospective resolution applicants. That information also, the managing that information, that data also responsibility of insolvency professional, and we should be able to manage this properly by preparing the critical information like financial information, the current of the assets, liabilities, and the critical information like some company which is critical for taking decision for resolution of the company, which will support the SRA, has to be provided. Not every information which is not useful has to be put. So perform duties as quickly and efficiently as we have discussed. The timelines are very, very critical. And then comply with applicable laws in performance of duties, observance of confidentiality. Many of us are aware that there are some numbers which are prescribed. The IP should not take up the assignments, too many engagements. The restriction included here. So when we are accepting assignments, so when we give consent to NCLT for our to the creditor. We will be filing one consent form with as per NCLT rules. In that also, we are giving our details of current assignments. So when even NCLT will understand, it is difficult. We will not be able to perform, give our best to that CD. So always you ensure that we are not accepting too many engagements, which will again will not give quality time to for resolution or resolution of the companies. And remuneration and cost, this should be in a transparent manner. As we all know, the cost incurred during the processes is called as CIRP, is called as CRP cost, and during liquidation it is called as liquidation cost. So when the resolution professional is incurring a cost, we should be suggest when you are appointing some professional or buying some the incurring expenses towards buying any thing for the corporate debtor, please incur the cost as much as possible judiciously. How we spend for our personal, how we are cautious, and it should be you usually in the process that editors over email and take any gifts or hospitalities. Hope I'm clear till here. Any queries from members? For insolvency professionals under code, we have two agencies. One is our regulator, one is insolvency professional agency. So when we are registered as an IP with IPA, either ICSI IIP or ICAI IIP or ICAMI IIP. So IPA is our first, the regulator, the IBB, the board has provided the powers to insolvency professional agencies to lay down their own bylaws. The IPS has to provide additional requirements to be fulfilled for registration. And IPS. So IPA is also so the IP regulations are there for the monitoring the insolvency professionals, and the code has led IBBA and the other one is IPA. So there are processes under IPC. We have the, as in the insolvency professional will be handling the CIRP process, the liquidation process, voluntary liquidation process, pre-pack, personal insolvency resolution process, bankruptcy as a bankruptcy process, as a bankruptcy trustee. Just 2 minutes. I'm getting a call. Just 2 minutes. Sorry. Yeah. So as an insolvency professional, we will be handling the CIRP process, the liquidation process, voluntary liquidation, bank, personal insolvency process, pre-pack, as well as the bank personal and bankruptcy process. So when first getting the corporate debtor into insolvency process. So once the corporate debtor is admitted into CIRP process, professional, and the adjudicating authority will pass the orders wherein the code pass duties, responsibilities on the IRP2 or RP to manage the operations and assets of the corporate debtor along with the compliance of the process for restructuring or resolution of the corporate debtor. Here, the IRP or RP will play a very, very important role in efficient conduct of the operations as a going concern. And also, the insolvency professional has to be abreast with the industry specific activities. And IRP or RP has to optimally manage the corporate data till either conclusion by way of resolution or revival, or if resolution is not um, attained, the liquidation. So if the CIRP process fails, during the CIRP process, the role of IP is very, very critical. As I was previously mentioning, once the application gets admitted, once the application gets admitted and CIRP process initiates, immediately RP has to take over control of the assets of the CD and issue public announcement, invite the claims from the creditors, and after collation of claims, constitute the committee of creditors and have the first COC meeting wherein the IRP will appointed as RP, or otherwise if creditors are willing to appoint another, replace IRP with RP, a new RP will be appointed. He will carry on the process from there on, and valuers has to be appointed by the IRP or RP, and the valuers registered with IBBI, empaneled registered valuers only to be appointed, and the valuation has to be, and the methodology of the valuation has to be placed before the members of committee of creditors before finalizing the valuation reports. The valuers, the IRP has to invite the valuers to explain the methodology to the committee of creditors, and the valuation, the two valuers have to be appointed. And if there is a significant difference between the two valuers, the third valuer has to be appointed and the average two of the nearest valuation will be taken up. More important, marketing efforts which RP is going to take up, a draft document has to be placed before the COC and take approval from the PRS for resolution. Evaluation matrix, which will evaluate the PRS on the basis of the marks, qualitative, quantitative parameters. Then one RFRPA and VDR has to be prepared by the insolvency professional. RFRP is request for resolution plan, which will contain the details of the CD and the manner which the resolution plan will be submitted. And in case some commercials which has to be included, like if CDs are going concern, what happens to the surplus earned during the process, how it has to be distributed. Is there any mechanism which COC want to propose to the PRS? All these important aspects to be addressed based on the each specific CD issue. RP has to prepare the documents and in compliance with the regulations. And once the and also ensure that no promoters come in back route through the resolution process. Section 29A due diligence is very critical, and majority of the assets RPs are what they are doing is they are taking the reports from the due diligence. If they take third party professional reports, that will be helpful, because this declaration we are going to give in form H to NCLT also. So when resolution plan approval we are going to NCLT, NCLTs are asking basically 4 or 5 very critical queries from RP. One of them is whether Section 29A due diligence affidavit is submitted and due diligence is done along with other compliances. To be paid, PF has to be paid, TDS, GST, going concern, compliances during the process. And also once the resolution prospective resolution applicants start asking queries during the diligence time, we should be able to attend the meetings, organize the meetings, attend the meetings, prepare the query sheet answers, responses to them, and make available all the information, because the PRS will again, in case even during the COC meetings, the creditors will ask whether the PRA due diligence team, we have to update regularly to COC on the status of the process. So during the diligence also, how we are supporting the PRAs, what kind of efforts we are putting in, all those we have to minutize in the minutes, because COC minutes, preparation of COC minutes or stakeholder consultation committee minutes, try to include all material efforts which you are you are putting your best efforts for the compliance. In case some compliances you are unable to do due to some unforeseen things, then that also need to be minutized. Don't think that if you are not complying, you can escape by not including in the minutes. So ensure that, because whenever IPA or IBBA comes for inspection, they are very aware, they are very thorough with the timelines, processes, and even if you miss out including in the minutes also, they will have their own checklist and their own mechanism to find out things. And always ensure it is transparent, minutes are recorded. Even if something is not done, try to admit in case if there is any non-compliance. So many IPs have faced a lot of issues while disciplinary action was initiated. So try to be always simple and straight to their queries. So in the CIRP, so if there is a resolution and the switch challenge mechanism or whatever process you are going to have for the assessing the competition between the resolution applicants. So once and also there is a duty on the resolution professional to put all the plans received up for voting. Now the new guidelines regulations say all the plans has to and ensure that the plans are put for voting, and it is they will be voting on the plan. And once the plan is approved by COC with 66% voting, then the plan will be submitted to the NCLT adjudicating authority with the compliance form of Form H. So ensure one more thing is, you ensure when you are filling the Form H, the corresponding data in the COC minutes are properly. So what has happened is, in one of our case, we the technical member was so sharp, he correlated the voting with the Form H, and he was able to catch that there was some difference in the Form H what was filled along with in the COC minutes. So this was, see, in Form H there is one column which says the voting percentage approved with the dissenting FCs and assenting FCs. So when in COC minutes we record completely who have voted, who have not voted, whereas in Form H the dissenting FC was in separate column, because of which there was a difference in the percentage of voting. So technical member was so sharp enough. So what he said, he has asked this as a query, raised as a query, and he asked the RP to submit a memo for compliance, saying that why there is a difference between what is there in that Form H and all. But we have filled in Form H also, we have put a star mark, and under that column we have put note, and we wrote that maybe that was not noticed. So always ensure that when you are submitting any information to the adjudicating authority or IBBI, ensure everything, all the information to be submitted is uniform and that is correct information. There should not be any discrepancy or difference between the information in the minutes or what you submit to the regulators. And one more responsibility is the PUFE. That I can say that is also very critical. Filing a identifying and determining on the preferential, undervalued, fraudulent, extortionate transactions, and filing an application with AA. And in case if any transactions are identified, I'm sure promoters will try to influence. And by the time they provide information and we come to conclusion on filing the IA, usually resolution professionals are appointing a transaction auditor for deciding on the uh, determining on the PUFE transactions. But however, this is only a supporting, but the code casts responsibilities on the resolution professional to file the application before AA on the PUFE. And the role of ethics comes, you have to navigate in case there is an influence from the promoters, they are trying to influence regarding the filing of the PUFE IA. Because in our case also, in one or two cases, the promoters were trying to influence for not filing the PUFE IA. So we have just understood how the RP has to function in the CIRP. So when in case if in CIRP process, the COC rejects the resolution plan, that resolution plan, whatever has put up for voting, has not received the requisite voting. And when the resolution plan is rejected, or when the AA passes an order based on the approval of the COC. So suppose if there is no resolution possibility, then COC will go for passing a resolution for approval of liquidation of the CD. Then also there will be a liquidation order. Currently, presently, there is a circular from IBBA which says the existing RP cannot be appointed as a liquidator, and majority of the NCLTs are following this. So the role of liquidator is again a little different from that of a resolution professional. Here, liquidator is authorized to sell the immovable property of the CD in liquidation through public auction or a private contract, or either collectively in a piecemeal manner. Also, it can be sold. So here the IBC has given a discretion to liquidator, but however, in consultation with the stakeholder consultation committee. So usually consultation committee. So before the stakeholder consultation committee members will be usually the members of committee of time. So liquidator has to immediately call for SCC and place whatever the immediate requirement or agenda before the SCC, taking cognizance of liquidation commencement on the CD. But there is a difference between the role of insolvency resolution professional and liquidator. The resolution professional is bound, resolution professional can appoint the professionals and take the decisions. But however, under section 28 RP, without the approval of the committee of creditors, that is, he has to compulsorily take 66% approval. And also there are resolutions which require the approval of COC, without which RP cannot take up some actions in the CIRP process, like appointment of auditor, internal auditor, or dealing with your subsidiary companies, related parties. So this section 28 restriction compliance ensure that some things cannot be done by the RP without approval of COC. But however, in liquidation, the liquidator however, now as per the new reporting requirements, liquidation forms and all, and regularly he had a SCC is not accepting with the decision of the liquidator, then why they have not accepted, and why liquidator has had a discretion to take this decision without approval of SCC. All this has to be clearly recorded in the quarterly reports which the liquidator is going to file. So as we all know that there are a lot of forms which we are filing with IBBI, and almost every information is captured into that forms. So while filling the information also, all the correct information has to be filled, because whenever any regulatory inspection or investigation happens, everything, all the documents will be verified and there should be uniformity. So when we are filing IBBI form, some information is entered. Whereas in what the quarterly progress report we are submitting before NCLT, there is some information. If all there is inconsistency, this shows the kind of approach to the regulators, and this is going to impact seriously. So as we were reading, we were going through the insolvency process liquidation. There is also one for the CIRP and liquidation process. This is for the insolvent companies. Code also provides for voluntary liquidation of a solvent company under section 59. So here also an insolvency professional can be appointed as a liquidator for carrying on the voluntary liquidation process of the company, of a solvent company. And there are, again, this is a timeline, stricter timelines to be followed to complete the voluntary liquidation of a solvent company. Apply to the adjudicating authority. And during these processes, RP liquidator has to ensure that they are opening a separate bank account, especially in liquidation and voluntary liquidation. It is mandatory to have a separate bank account. So ensure that entire receipts and payments are managed properly, correctly, ethically. And if you see the voluntary liquidation process, anything above 5,000 has to be routed through the bank account only. So there is an audit of receipts and payments account. So NCLT, like in very, very, very clear, is presented to them before passing the dissolution order. So they will verify the majority of the receipts and payments during the process. So when we are functioning as a insolvency professional, as RP, IRP, or liquidator, or bankruptcy trustee, we have to take such actions that is necessary to perform the duties for success of that process. Like suppose if it is voluntary liquidation, what are the efforts in case if there are some legal issues which have come up during the process? What are the best efforts you are putting in? This has to be recorded in the stakeholder consultation committee, stakeholder meeting minutes, because of the timelines. And always the IBBI, whenever they investigate, the inspecting authorities always ask why there is a deviation. In case deviation is there, why there is a deviation, and what kind of efforts you have put into ensure that you are putting all your efforts to close the issue. So we know that whatever the legal framework prescribed is the insolvency bankruptcy code, and all the rules, regulations, circulars which are notified under the code. So if you go to the IBBI homepage, there we have all the legal framework. So when we go to the legal framework, there under legal framework, you get the code, then regulations, rules, circulars, and quarterly, the reports are also there. But the legal framework is, for CIRP, there is a CRP regulations. For liquidation process, there is a liquidation process regulations. For voluntary liquidation, there is voluntary liquidation regulations. And specific to whenever there is any, till the law was settled, most of the times, like in JP Infra, home buyers, and the powers of liquidator, resolution professional, claims, and difference between the financial creditor, the constitution of COC, the related parties, section 29A, and the powers of the committee of creditors. Just 1 minute. ఏం క్యారల్ వీళ్ళు ఇంత గట్టిగా కొడుతుంది, వచ్చి ఒర్లొద్దని చెప్పి. గుడియాతో అయ్యో క్యారల్, ఈ ఆడియో ఒక్కసారి ఓపెన్ చేయవా? రేణుకాంట్ వస్తుంది, ఓపెన్ డోర్ పెట్. I'm sorry, there was a slight there was a disturbance. I'm sorry. So the legal framework is Insolvency and Bankruptcy Code, rules and regulations, circulars notified under the code. Then we have business laws, whatever applicable business laws. If suppose a company is a financial sector company, or if the company is a uh, not sector, um, just the company is into pharma company, real estate company, then that specific business laws are applicable to them. Then the RP has to ensure that comply with the business laws. Like for real estate, they have to ensure it's done. Then the specific general and commercial laws also. Then applicable NCLT rules. See, the insolvency professional or liquidator will be always filing the applications before the NCLT for various issues which they come across. So we have to ensure that we are aware whatever our advocates are preparing is in compliance with the NCLT rules. So accordingly, the IP has to ensure that they are ensuring that the IBC code and the relevant applicable regulations are followed. And while discharging the functions, they have to see that whatever there is no prohibitory kind of actions which IP is doing in discharge of the functions. So we have a question. Why there should be, why there is a need for regulating the actions of the insolvency professional? Can anyone answer? So they, oh, sorry. So the insolvency professional will be managing the entire corporate data. Uh, uh, So insolvency professional has the abundant powers here. So the insolvency professional is managing the entire stressed asset, managing it as a going concern, and the powers are vested with the insolvency professional. And lot of insolvency majority, not majority, few of the insolvency professionals has misused their power. And although initially, see, for every profession there is a code of conduct, like advocates, medical professionals, chartered accountants, or company secretaries. In the similar way, insolvency professionals also has a code of conduct, but however, in our profession, in insolvency professional, there should be very strict code of conduct, because it is, again, we know that insolvency professional is there only for certain period of time, and the process is carried on vested with the abundant powers in extra caution has to be put in by the insolvency professional while discharging his duties, because the actions of insolvency professional will affect the value of a corporate debtor, and the actions of insolvency authority and IPBI, and even the adjudicating authority by way of regularly quarterly reports, and some NCLTs are in. Uh, so insolvency professionals are responsible for the complete CIRP process or liquidation process, and the interest of CD is involved. So we have huge stakeholder base like creditors, employees, and when the reports go to AA, even they understand what exactly is happening in the process. So in our cases also, in CD we had leasehold premises in some government offices. Our C So CD was the corporate debtor where I was the resolution professional. The CD had a lot of leasehold premises in the offices, which we are trying to remove, the asset value gets eroded, almost gets to 5 to 10%. So we took NCLT approval and for leasing out of the furniture of the CD in the premises of the lease in the lessor. See for the insolvency professionals, that is IBBI IPA. Then under the IBBI, the monitoring insolvency professionals or registered valuers or information utilities or the IPEs. See, although this IPE word is not there now, since IPEs can be also IPs, the IBBI has set up a investigating authority and disciplinary committee. So when we see, the investigating authority refers to a person or entity which is appointed by IBBI to conduct the investigation into potential violations. So what are the violations by the insolvency professional under code or by the IBC regulations, the applicable code of conduct. So this power is vested with the investigating authority under section 218 of the IBC code. Then there is a disciplinary committee under, this is the next level. One is the investigating authority, which will go very detail into the process for which there is a complaint. See, usually what happens in against IP, this will be referred to the disciplinary, that will consider the reports from investigating authority or IPA. Based on this, the committee will take action against the insolvency professionals as per the applicable guidelines. So if we see what is the responsibility of investigating authority, here inspection, investigation of the insolvency professional is conducted by the IPA. And what are the powers is, the investigating authority constituted under IBBI can call any person to furnish such document, record, information in the course of inspection or investigation. And they can enter into any building or place where they have reasons to believe that any document or record relating to that matter of inquiry is there. Then what is the responsibility of investigating authorities? They can seize any document, record, or take extracts of the copies and keep them under its custody. Also, they provide the reports to the disciplinary committee for the next course of action to be taken against the concerned IP or IPE or registered valuers or IU. And there is a once the investigation authority completes their investigation or there is an inspection and inspection is completed, a report is submitted to disciplinary committee. So on the examination of this report of investigating authority, if disciplinary committee is satisfied that sufficient cause exists, it can impose any penalty which is provided under the regulations. That is, either they will suspend the registration or they will cancel the registration for certain period of time. Or they may direct the person who had made some unlawful gain or ask the person to, the professional to make good the loss or deposit that loss into the IEPF account as per the applicable regulations. So here the role of disciplinary committee is they have to consider the reports of investigating authority, then they will impose penalties or cancellation of registration. Here, the quantum of penalties is 3 times the amount of the loss caused to the persons concerned for contravention, or 3 times the amount of the unlawful gain made, whichever is higher. So when we come across the various provisions, one of the important section I can say is section 208, which lays down the functions and obligations of the insolvency professional. So if we see, there are certain reporting requirements which every insolvency professional is supposed to take up. So we have section 208, section 217 to 220, wherein the inspector appointed based on will carry out investigation, and the officer so appointed can go and investigate the employees, agents, and also investigate to preserve and produce all the books in the custody of the company. And in case if they need any assistance also, they will seek for it. The inspector himself may require any body corporate to furnish information as he may consider necessary. So even the inspector has a power to examine persons under oath. So even taking person on oath, he has the powers. So here the inspector is a officer who has appointed by is from the central government. So he will have all the powers like a CPC, court officer. The officer can take all the assistance from the relevant statutory or authorities or police, inspector of police. The central government may enter into agreement with the government for inquiry or investigation with any government or foreign reciprocal agreement they can have in foreign countries also, in case if there is any investigation which is required to be done on the foreign assets, then they can have a reciprocal agreement. So here again under section 219, the inspector will have all the powers to investigate having nexus with a company under investigation. That means if investigation has to go beyond the company which is related also, they can go. So we'll go to case studies now. So basically, what are the lot of issues wherein show cause notices are issued and where there are a lot of violations, which RPs, the insolvency professionals have done beyond the circumvented the code regulations and have violated the applicable provisions in the processes, and there are disciplinary actions against them. That is, they were navigating the process, but they are deviating the process applicable guidelines and they were not adhering to the code of conduct. So can we have 5 minutes break and assemble around 4:25? Can we assemble around 4:25? We can close by 5:15.
Okay, ma'am. Okay, ma'am.
Quickly, we'll just join around 4:25. Thank you. So we'll start, Anjali ma'am. So welcome back. Yeah, welcome back. We will be dealing with the various disciplinary committee orders wherein IPs were issued show cause notices. And these few case studies we'll go through so that we will understand exactly what are the contraventions and where are the violations and where is the improper conduct on the part of the insolvency professionals. So majority of the cases where we have observed IBBI is very, very strict in case if there is misappropriation of funds or lackadaisical approach in incurring the cost or there is a violation of code of conduct, and especially when there is financial irregularities by the RP. the IBBA has given very, very strict orders against the IPs. Like they have almost suspended the license of the insolvency professionals. So some case studies will go through. Here, the insolvency for the I felt the names of the insolvency professionals I will not take up in my presentation. So these are the case references from IBBA portal only. So here, the insolvency professional was member of ICI IIP, wherein show cause notice was issued by disciplinary committee. The IP has violated the timelines in conducting the voting and the meeting of the committee of creditors. So here the timelines are very critical, especially when there are home buyers. You have to ensure the authorized representative gets the sufficient timeline window, voting window timeline for the voting. And even there was an improper conduct of voting on the resolution plan. So when the resolution plan was voted, the insolvency professional has done, the insolvency professional has to put up all the resolution plans for voting. So here he has put up only the compliant resolution plans for voting. So the DC took a serious view on this. And there was also delay in submission of relationship disclosure forms. IP has the appointed various professionals and he failed to submit the relationship disclosure forms within the applicable timelines. So as many of us know that the within 3 days of appointment, we have to file the disclosure on IBBI portal. So here burdening the already stressed asset with the unreasonable expenses. Here, for example, the claims were around 50 lakhs. The CRP expenses incurred were much more than the admitted claims. So the DC took a serious view of the conduct of the insolvency professional, and in exercise of the powers, the disciplinary committee has suspended the registration license of IP for a period of 3 years. So this is first case law, and when we go to the brief details of finding in the inspection report, the CD was King's Electronics Private Limited. There was a irregularity in voting process. And here there is a contravention regarding the seeking appointment as liquidator without the consulting CEO. This was in violation of section 20A and 39D of CRP regulations and IP regulations. Here, as we have seen in the previous slide, that the IP license registration was suspended for 3 years. We'll go through this case study too. Here, the IP was IPA member of ICA Institute of Cost Accountants of India. He was acting as RP as well as liquidator of IVRCL, wherein show cause notice was issued when the insolvency professional was in the capacity of liquidator. Below, some of the contraventions are like the non-refundable participation was requested from the prospective resolution applicants along with the EMD. See, when you go through the regulations, it is very clear. You can ask for refundable participation fees, whereas non-refundable participation fees is violation. And there is a delayed valuation during the liquidation process. See, there are certain timelines which always the timelines are prescribed for important activities which we have to take up. So the period for getting the opinions or valuations done from the independent professionals should not take lot of time. So the valuation there was a considerable delay in getting the valuation done. And even there was inconsistent charge of fees for himself as a liquidator, also for the firm where he is a partner. So here the IP has charged inexorbitant fees for himself as well as the insolvency professional entity where he was partner for the support services. So here the disciplinary committee, in exercise of the powers, they have suspended the registration of IP for a period of 1 year. Then we have the case study 3. When the inspection was conducted, who is member of ICSI IIP, for the CD JSM DevCons, a show cause notice was issued for charging a fee for verification of claims. So here, I want members to take a note that the powers, roles, responsibilities, duties cast on the insolvency professional cannot be delegated. The insolvency professional is not supposed to delegate the roles and responsibilities and his duties cast upon him under the code and applicable regulations. So sometimes actually initially when IBC, during initial IBC uh, IBC was promulgated, many of the insolvency professionals were outsourcing the work of verification of claims to third party professionals. So this is or IPs, they have taken a serious view. The IP has outsourced his work and he has charged around 1,87,000 for verification of claims. So the disciplinary committee 1,85,000 fees, whatever he has charged. So usually IBBA is asking the insolvency professional to deposit the money into the Bharat Kosh, into the Investor Education Protection Fund. We will go through the case study 4. Here, the inspection report was provided member of ICSI IP in the CD of Hirakud Industrial Works Limited, where show cause notice was issued for constitution of COC without verification of claims and inclusion of into the COC the related parties of CD who have been unduly assigned voting rights. And here RP also failure to obtain claim from workers of the CD. See, when we are inviting the claims, especially see when now after amendment, the responsibility is on RP to issue public notice, also send intimation by email or letters correspondence to the creditors as per the latest books available, to the address available in the books of accounts or with the records of the CD to all the creditors. So here the insolvency professional has failed to obtain the claim from workers. The insolvency professional has acted not in good faith. He has facilitated the erstwhile directors of the CD for extinguishment of their liabilities and also from prosecution from criminal offenses. Here he would have filed some filings on behalf of the directors for extinguishment of their liabilities or some wherever criminal cases are there. He filed some submissions on their behalf. Then also admission of a resolution plan by SRA being a related party in violation of section 29A. So here, if you see, the IRP has facilitated the promoters and he has given backdoor entry. If you can see, the entire conduct of the RP is in violation of provisions of the applicable regulations as well as code of conduct. So disciplinary committee has taken cognizance of violation of section 18, 23, 25 to 208 to regulation 7.2 of IP regulations, CRP regulations, as well as code of conduct. So many violations. So disciplinary committee has cancelled his registration. So when the insolvency professional is conducting the CARP liquidation or any processes, complete diligence has to be exercised and within the applicable provisions, not to get influenced by the interested parties. Sometimes see, NCLT will, creditors will come and pressurize RP to file the claim. Creditors will come to RP and will pressurize him to admit the complete claim. In spite of deficiency in the documents provided, in spite of factual difference or not balance as per the corporate debtor financials, all these RP has to be very diligent in exercising the powers. Sorry, there was a small disconnect. So when the disciplinary committee is cancelling the registration of the insolvency professional, there are major deviations which RP insolvency professionals are taking. So when there are major deviations, the disciplinary committee or IBBI is taking a serious view. If we can see in the past, the big four, some of the big four paneled insolvency professionals also for contravening some provisions and also making financial benefit out of the CD proceeds and not being ethical in discharge of the duties as an insolvency charging to the IPs where they are IPs, where they are appointed as support services. The IBB has taken a serious view and cancelled very big IPs registrations also. So if we go to case study 5, here the IP is a member of ICI IIP, where CD is CM Jewels Limited. Where the current RP who was acting as RP was replaced and show cause notice was issued for okay, sorry. Here the RP was RP has accepted an assignment without having a valid AFA. As all of us know that the authorization for assignment has to be one of the duties of IP is to ensure that we renew our authorization for assignment. That AFA is also renewed based on our performance during the year. In case if we have assignments, the IPA and IPBA will review. IPA will review whether we have filed all the requisite forms, we have conducted the process in a fair and transparent way, and all the compliances are done within the timelines, or any deviations any disciplinary actions taken, all those are considered and we get our AFA renewed. And that AFA is valid only to some date, some specific date. So when that date has passed and you have not applied for AFA renewal, you are not supposed to take any assignment or give any consent for the assignment. The IP has given consent to one of the assignment, which was brought to the notice of the DC, and the IP's license is suspended for giving consent without holding a valid AFA for 1 year. Uh, We'll go to case study 6. Here, the liquidator, this case is in liquidation, where the liquidator has wrongfully denied to admit the claim of EPFO received during the CIRP process. See, now you see the regulations and guidelines. In case a creditor submits a claim during CIRP, the liquidator during the liquidation process has to consider the claims received during the CRP also as claims received during the liquidation. So EPFO has not submitted the claim during the liquidation. The EPFO has submitted the claim in a different form. So the liquidator was continuously writing to the EPFO to file the claim in the prescribed form. But the liquidator has sold the assets and paid to all the stakeholders and closed the company and filed for NCLT for dissolution of the company. After dissolution, PF has filed case against the IP. So here the disciplinary committee has held that even though the claim is submitted in a different form, IP has to consider the claim in the list distribution of the amount. So here the disciplinary committee, after considering the violation, which as per section 208(2)(a) regulation 30 of liquidation regulations and violation of code of conduct and IP regulations, 56. You imagine if the claim amount runs into some lakhs and crores of rupees and not admitting social beneficial legislation. I request all the insolvency professionals who are RPs or liquidators to take an informed, expert PF professional, practiced professionals guidance in admitting the claim of EPFO, and also in the resolution plan when SRA submits the amount distribution to the creditors, ensure that entire admitted claim of PF is provided as per the Jet Airways case. So here disciplinary committee has imposed the penalty to the tune of the claim amount. If we see case study 7, here the member is IP, who is member of ICSI IIP, was a liquidator. There was a irregular constitution of stakeholder consultation committee. Class of creditors belonging to other class. There was a clear regulation 31A violation. So there was a non-representation of liquidation costs in the SEC meetings. As I was discussing during my presentation, especially the CRP liquidation cost, the insolvency professionals has to exercise due care, diligence, and ensure the approvals are in place for all the costs. Even in IBBI forms, you have to fill. Also, the liquidator took a lot of time there was a delay in issue of issuing public notice for first auction, second auction beyond prescribed times. That is, within 45 days from liquidation commencement, the first auction has to take place. Then again, within failed auction, 15 days respectively, without any here, if you want any extension, we have to go back to SCC for extension of issue of public auction notice. There is a serious violation in constitution of SCC. Here, there was a class of creditors in among banks only. Some of the banks have the security they have not relinquished in favor of the liquidation estate, and some of the creditors have relinquished against the liquidation estate. So among the class of creditors, the representation of the some of the banks were not there in the SCC. So the SCC has complained against this. Then the IBBI disciplinary committee has suspended the authorization for assignment of IP for a period of 3 years, and the IP is supposed to comply with the applicable liquidation regulations. Like, he has to involve all the stakeholders in the SCC meeting and maintain transparency and trust in the liquidation process. That means the cost, whatever is incurred, and whatever are the first auction, second, first failed auction notice, all those timelines have to be, anything happens in the process has to be reported to the creditors. Here, the disciplinary committee has taken, there are lot of guidelines prescribed in the IBC ecosystem, and particularly RP has to ensure the applicable laws has to be complied with. And especially if there are deviations in procedures or shortcomings in the processes, that is will be taken very in a serious view. Here, there are a lot of contraventions. If we see the insolvency professional, while exercising the duties under section 28, there are certain items prescribed which RP is not supposed to take decision on own. He has to take approval of the committee of creditors with 66% approval. One of that is for appointment of statutory auditors, the RP has to take prior approval from committee of creditors as per section 28(1)(m). He has not taken approval of COC and appointed statutory auditor. Here, RP has submitted that prior permission was taken, but in the minutes, this was not approved. See, when DC or inspecting authorities come, even there are violations, we should be supporting with the inspecting and disciplinary committees. We cannot go and tell something which is irrelevant or which is not exactly the fact. We cannot lie, and because everything is in record, everything is recorded. Whatever during the process, you prepare the documents, you file all the forms at regular intervals. So you can't transparent when we are presenting to inspecting authorities or disciplinary committees to before IPA or IBBI, so that even if there is any possibility of support for any minimum violations, that committees will consider. Like that, some orders are there where the committee has understood the factual scenario in the process, and they have reprimanded and left the IPs with only advice. But if major non-contraventions, Disclosure, transparency. Here, non-cooperation by suspended directors continued. But however, Mr. This IP has not filed, even the suspended directors failed to provide him with the documents. The IP admitted the approval of resolution plan. We are at this stage, hence I have not filed the application. Here, I think the details of the assets were not clearly indicated in the IM. And the IP gave different version to the before the authority about the information which was not provided by the erstwhile directors, and the RP has not filed any application for non-cooperation. When this was asked, he said, I was trying to file, but I have not filed because we are at the stage of approval of the resolution plan. And also RP tried to blame the IRP because he has taken over the process from IRP. He said that some details of cash collections and minimum information was provided, and majority of date of acquisition and even the current state asset. And again, there was a mismatch of wrong dates in the RFRP. Then again, issues with regard to filing of avoidance transaction. As I was presenting during my presentation, I said Form H depicts what has happened in the entire process. Even in now, the form like Form H compliance certificate, which contains entire process related information. If someone goes through Form H, they will understand. So here there was a contradiction regarding the PUFE application and the information in Form H. Now RP is saying this was erroneously written. And there was a discrepancy in the list of PRAs. When the PRA list was issued, there was a discrepancy. Then the RP has not filed the application for extension of CRP period. Now RP is saying our application has to be filed strictly within 180 days. This was filed after 180 days. Why 180 days? I have not filed within 180 days. Why this point? Then failure to reimburse the ratified amount to operational creditor or applicant. See, the amount which was supposed to be paid to the operational creditor as a CR as a cost, and this was already ratified. The operational creditor has incurred some supposed to be paid by the resolution professional. Now resolution professional is saying even after COC ratifies that funds are not available. This can be Sorry, there was a slight disconnect of network. We'll just conclude in 5 minutes. We are discussing the last case law. Hope I'm audible. Hello. Hello.
Yes, you are audible.
Yeah,
Yeah.
audible.
Okay, sorry, there was a network drop at my end. So we were discussing the last case study, where that is a very recent one, and there are majority of non-compliances by the insolvency professional. Uh, Hope the case study 8, the last case study I was discussing with all of you. I'm unable to share also after network drop. So the recent, I'll share the PPT with all of you after the presentation. So in the last case study which we are discussing, there was major non-compliances on the part of IP. He has failed to take approval of COC for appointment of statutory auditors, and non-cooperation was there from the suspended directors regarding the status of the assets. That was also not, the RP has not filed non-cooperation IA. He has failed to provide mandatory and important information in the information memorandum about the assets, and also he has given inconsistent informations in the very important documents which he has responsibility to SRA and COC, that is wrong dates are given in RFRP. And also there was issues regarding the avoidance transactions. There was contradictory statements in the section 66 application which he has filed. You have to maintain consistency in the documents, in the information and the facts which you are disclosing to in the COC minutes, SCC minutes, or with the regulators, NCLT. The correct information has to be reported, and there should not be any discrepancy. There was a discrepancy in the list of PRAs issued, and also he has failed to file application for extension of CRP period within timelines. And when the COC has approved or ratified some cost to be paid, he has not paid. He said, let us pay in liquidation. And the resolution plan was submitted without performance bank guarantee. And there was a difference in the numbers mentioned in the resolution plan and the COC minutes. So there are larger number of issues. So DC, after hearing and conducting the investigation, after the inspection or investigation, and the DC after hearing, issuing the notices, they have suspended the registration of insolvency professional for 1 year. So there are certain inferences on the entire insolvency system, how to function with minimal. See, when the code was promulgated, the what was expected was the minimal intervention by courts or agencies. They wanted to give an independent function where the specialist is appointed for reorganization or restructuring. So the probability of effective reorganization will increase when IP functions within the framework and with applicable code, within the framework and with the traits which he is supposed to exercise in the code, in the conduct of the process. So all these capacities will depend only on a sufficient experts which the market has, that is the expert insolvency professionals. So I would like to just conclude with few remarks that the effective role of insolvency professional calls for multiple skills, not only the skills of laws, compliances, business, or financial understanding of the financials. Uh, Along with this, we have to understand the people management, stakeholder management, how to manage the stakeholders in the process, then strategic foresight, and a lot of personal traits are required for success of the process which is entrusted to you for either resolution of the CD or liquidation of the CD, or for personal insolvency, or whatever the process is entrusted to you, along with the whatever skill set I have mentioned. It also depends on personal skills of the insolvency professional also, and for which I suggest there should be continuous training, which the insolvency professionals has to take through various IPS are conducting various webinars or even physical seminars they have to attend, and also have some peer discussions on the topics. As we have CSR, I was mentioning, we should have professional social responsibility. As an insolvency professionals, I feel we also indebted to have our own social responsibility for success of the process, which is going to impact the economy. So different traits are required for managing the going concern, and also marketing skills are required to bring the resolution of the CD, or to bring the buyers for prospective buyers for e-auction. Also, conduct of all this, we should have highest ethical standards. We get various forces which will try to influence, but has to act within the framework and moral values and the personal on not getting influenced. And these are the various few things which I would like to present on the how to navigate as an insolvency professional. And one suggestion I would like to make here is, in Australia and Ireland, they have made professional indemnity insurance. So likewise, in case if we are handling any big cases, or where material flooded, so it is suggested that we should take some professional indemnity insurance. Some of the insurance companies are offering this. When I have taken up the assignment, I have foreseen lot of risk and responsibility. So I have taken insurance. So this is one very very important critical thing for financial indemnity. Any risk, uh, risk is involved. So I feel it's a noble profession, but high risk, and we need to navigate these processes with professional traits, always upgrading our knowledge, skill set, and also personal traits plays a very 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 vital role. Thank you. Any queries or questions? Any questions from the participants? Or if they want to share any of their best practices, or how to navigate the processes as an IP in CIRP or liquidation. Any participants want to share their experience or any queries also? I can answer. The PPT will be shared with you all. If no questions, Anjali ma'am.
Hi, ma'am. This is Saurav.
Oh, sorry. Saurav, you are there?
Yes, ma'am.
Hope the webinar was useful to the members. And thank you to ICSI IIP team and
Thank you, ma'am. Thank you for your valuable insight and your learnings sharing with us. It was a wonderful webinar. Thank you.
Thank you. Thank you all. Good evening.